Hi, I'm Alina Altamirano from ICallMyLawyer.com. For over 5 years, I've helped families protect what matters most through thoughtful and personalized estate planning. One important but often overlooked part of that process is incapacity planning, making sure your wishes are respected and your loved ones are spared unnecessary stress if you're ever unable to make decisions for yourself. In today's video, I'll answer some of the most common questions I hear from clients regarding incapacity, like what it means, why it's crucial to plan ahead, and which legal documents can safeguard your future. Whether you're just starting to think about your estate plan or reviewing an existing one, this information can give you peace of mind and help you take the next step with confidence. Let's get started. The first question is, what does incapacity mean in estate planning? Incapacity means that you're unable to manage your own personal, financial, or medical affairs. This may be due to an illness, an injury, or a mental decline. It could be temporary, but it could also be permanent. A lot of temporary incapacities have to do with an accident, such as a car accident, or a slip and fall accident, where you may be unconscious and incapacitated for a period of time. Planning ahead ensures that someone you trust can make decisions for you without any court intervention. Why should I plan for incapacity now? Well, life is unpredictable. We all know that. If you become incapacitated without a plan, your loved ones may have to go through a lengthy and costly court process in order for them to be able to make decisions for you. They're not going to have decision-making authority without a court process. Having those legal documents in place that we'll be discussing in some of these questions today is going to protect your wishes, ease the stress on your family, and prevent any disputes. What are the documents that we use for incapacity planning? Common incapacity planning tools include a durable power of attorney, a healthcare power of attorney, a living will, and HIPAA authorization. The durable power of attorney allows a trusted person to be able to handle your personal decisions and finances. The healthcare power of attorney, also known as healthcare proxy or healthcare surrogate, appoints someone to make medical decisions only if you cannot make them yourself. And living will states your preferences for end-of-life medical care. This was commonly known as a DNR, do not resuscitate. It's basically giving instructions, pardon my language, as to when to pull the plug. And the HIPAA authorization is just a document that allows your loved ones to access your medical information without a disclosure written by you while you have capacity to do so. The doctors are going to be bound by statutes and laws that do not allow them to share medical information. The next question is, who should I choose as my decision maker? You should definitely select someone whom you trust, that understands your values and preferences, is a trustworthy and financially responsible person, and somebody that can stay calm under pressure. You can name different people for financial and healthcare decisions if you prefer, like having somebody who is more, is a better suited person for financial decisions. And you may have somebody else who may be better in making healthcare decisions. A lot of my clients have children who may be in the medical field, and those are definitely the ones that end up making the healthcare choices. But they may have others who are savvier investors or have more experience working with finances, and that may be the financial power of attorney. So what happens if I don't have an incapacity plan? When you have none of these documents, your family may need to petition the court for a guardianship procedure. This process can be expensive, time-consuming, and definitely emotionally draining. And the court, not you, will choose who will manage your affairs. That means family struggles, disputes, you name it. Can I change my incapacity documents later? Yeah, as long as you have mental capacity, you can change or update. You can revoke your existing powers of attorney, your living will, any other planning document at any time, except if you have set up an irrevocable trust, which is not something that we're discussing today. Does a will cover incapacity? This is a common question, believe it or not, because some people think as long as they have a will, they're all set. First of all, a will does not avoid probate, but it also does not cover incapacity. A will only takes effect after death. Incapacity planning documents, the documents that we're talking about here, those are the ones that work while you're still alive, but you're unable to make your own decisions or manage your own affairs. How is a durable power of attorney different from a regular power of attorney? Well, a durable power of attorney remains in effect even if you become incapacitated. Those are the ones that we use on a regular basis. However, there are also regular powers of attorney that are non-durable that end if you lose capacity. For example, if you are in fear that somebody may make decisions that are not relevant to your beliefs and your wishes while you're incapacitated, you may want to set up a regular non-durable power of attorney, but it's not going to work if you need it at that point. Well, I hope this Q&A has given you a clear understanding of why capacity planning is so important. If you'd like to discuss your own plan or make sure your documents are up to date, visit our website at icallmylawyer.com to schedule a consultation. Don't wait until it's too late. Protect yourself, protect your family, and have peace of mind knowing your wishes will be honored and protected. Thank you for watching. I look forward to helping you plan for the future.